sorry if we've kept you waiting. By your clock, it's probably 4 minutes past by now.
I was just going by that, which is slightly fast, yes.
Yeah. Fine, thank you very much.
My lords, my lady, just to introduce my client who's behind me, I just wanted to make clear who are sitting behind me and that she's here in the appeal. I said I'd pick up a couple of factual points after the adjournment. The first one relates to the question of whether phone or video or both in the relevant period were available. And there's two places where the evidence deals with that. The first is in the detailed grounds of defence, which is signed, that's at Core Bundle 205. Paragraphs 13 to 14. And what the defendant below explained was that halfway down 13, detained individuals are advised of the surgery service that's held on Tuesday and Friday each week during their induction to the Immigration Removal Centre, and told that requests for legal advice should be made to the welfare team. The welfare team then arrange with the duty solicitor to contact the resident on the days the surgeries are held. Initial contact at present between solicitor and detained individual is via telephone, with the solicitor being provided with the detained individual's mobile phone number.
Sorry, I've lost which paragraphs.
Paragraph 13 on page 205.
We're on page, in my bundle, we're in page 203.
Apologies, it may be
203, that's what 3
So it is 203. Yep. My numbers are hard to read. 203, sorry. Video conferencing is available, but Mighty, who operate the IRC under contract from the Secretary of State, have indicated that the preference by duty solicitors and detained individuals is to communicate by phone. Contrary to Women for Refugee Women's assertions, in-person legal advice is available at Derwentside IRC. The Legal Aid Agency's instructions for providers who are providing DDAS services at Derwentside under the current contingency arrangements are that when they are on the rota, advice may not only be delivered by telephone but also on request via video conferencing or in person. It appears to be the case, however, that no in-person visit has been requested from DDAS providers since the centre opened. And then Dr. Loosley was asked to comment on that evidence, and her evidence is in the supplementary bundle, in the relevant part, page 189. Paragraph 6 and 7.
Sorry, give me that reference again.
Page 189 of the supplementary bundle. In fact, if we go out to paragraph 5, she's talking about one person she spoke to who had discovered by a newspaper article on the 21st of February, Women for Refugee Women became aware the defendant had stated in-person legal advice appointments at Derwentside were also now able to take place on request. Following the publication of this article, I spoke to one woman in Derwentside who had not yet been able to secure legal representation to explain that it should be possible to request a face-to-face surgery appointment. She then asked staff in Derwentside about the possibility and explained to me that she was initially told by a member of staff someone would get back to her. She was subsequently informed she would have to speak to the contracted provider on the phone first. She had this phone appointment with the contracted provider, i.e. a legal aid lawyer, during which they said they could only help with a bail application. WRW has now been able to find her a solicitor who can help with her asylum claim. She has not received an in-person visit from the solicitor, however. I also asked the same 5 women who said they had not been offered the possibility of a face-to-face surgery appointment if they were made aware of that this appointment could take place via video call. Again, they said this was not offered to them as a possibility. They were offered only a telephone call. The defendant also states in summary grounds that Mighty, who operate the IRC under contract, have indicated the preference by duty solicitors and detained individuals is to communicate by phone. While this case is not about preferences, it's about rights, I've asked the same 5 women referred to in the paragraphs above how they found having legal advice appointments over the phone. All of them said they would prefer an in-person appointment, and failing that, at very least, a video call. So,
put aside the legal submission that's there. I mean, the there's nobody there saying that video conference facilities are not available, and it's simply people including solicitors, indicating simply a preference for telephone rather than video conferencing, or a preference for a video, at very least a video call. I mean, it doesn't, to pick up my Lord's comment, it doesn't go further than that, does it?
Well, it seems so. The word preference comes from the sort of hearsay account of what Mighty apparently have said to the defendant. But the more important part is paragraph 13 of the defendant's detailed grounds of defence, which admits that initial contact at present between solicitor and detained individual is via telephone. So it's not to do with preference, that's the system that was in place, was that first of all you get phoned.
Hang on.
But that plays straight into where we were at some point this morning, which is at that point if a solicitor felt that it was either necessary or desirable to have a video conference or an in-person meeting, they could. There's nothing to prohibit them from asking for one or setting one up.
And
Nothing to prohibit them.
And it's, as I understand it, it's the preference by the solicitors is to communicate by phone.
Well, according to Mighty,
Well,
according to the defendant's account of what its contractor has said,
well, is that
something of a hearsay piece of evidence, which is then disputed.
well, it's no more here or less hearsay than what's in paragraph 7.
I agree, but I'm taking the court to the evidence in answer to the question, the evidence that we have.
Yep, thank you.
The only other evidence that we have is the evidence of what has actually happened once the contingency arrangements ended, which is to indicate, or from which one might infer, that the preference both of individuals and solicitors has been has not been for telephone conferences, because we've seen that of the non-DDAS appointments, 0 were by telephone call, and of the DDAS appointments, only 3 in the period July to January were by telephone.
Presumably no, I'm sure this was the case, presumably no one was called to give evidence or cross-examine below.
About the post-hearing evidence?
About any of the materials that you've just given us?
No.
No.
So that's what I've been able to locate in terms of evidence on that question of how it operated. And the key point, as I say, is initially contact was by phone, i.e. the 30 minutes was by phone. I accept my Lord's point that there is then no prohibition. There was no rule that a solicitor could not seek to arrange a video conference, and evidently in some cases they did, because we have evidence that there were some video conferences. We do, however, have evidence that the number of in-person visits was extremely slim. The other matter on which I said I would come back is the cost of travel point, which is connected to arranging a conference. There's 2 pieces of evidence on that. One is Mr. Hussein's statement at 39 to 41, first of all. So this was the first statement of Mr. Hussein.
Can you give us the reference?
SB 39.
Thank you.
It's headed Financial Realities. This was dated 6th of June. And he explains something I alluded to earlier about the loss-making nature of trying to operate in these conditions. If my lord and my lady would just read through very swiftly through that, up to 75. And if I could just pick up 75, the key point is that Mr. Sain says that it's inconceivable how Duncan Lewis could risk not getting paid for the travel to Derwentside IRC. And he refers there to Shalini Patel's statement of the 18th of February, which set out her understanding at that point of how that would operate. But she then put in a subsequent statement at 194, SB 194, where she corrected a mistake on travel costs, having investigated it with the legal aid agency via a Freedom of Information response. It's a short two-paragraph statement. And at the top of page 195, she explains that the position is that the legal aid agency pays a fixed fee for attending the DDAS, depending on the number of detainees seen. The remuneration regulations provide that the fixed fee for a surgery visit is £360 for advising 5 or more detained persons, and £180 for advising up to 4 detained persons, including if you see only one. These arrangements mean that because of the travel times involved, it's not financially viable for Duncan Lewis to attend the surgeries, either from London or Leeds. As explained at greater length in my previous statement, it's also not financially viable under current arrangements with the legal aid agency. So that...
But it is, we know that, I mean, how do we reconcile that with the fact that there are 3 law firms who signed up to the new contract?
As I said earlier, we don't have evidence from them to explain the calculation those firms made about the loss leading exercise, but we do know that the largest immigration advisor in the country decided it couldn't afford to continue under those arrangements. Those 3 firms are very small high street solicitor firms, so it may be that they thought the expansion into another area was worth the experiment, or who knows, but I can't really speculate. But the point I wanted to draw from that is that my Lord Justice Stuart-Smith made the point that it might be seen cynically that attending is better from a fee perspective. In actual fact, it's the other way round, that the incentive was to conduct the surgeries by telephone because you avoid the travel time and travel cost, but still get the fixed fee.
Yeah.
So that was just to pick up the points before the adjournment, and I'll come very shortly onto the evidence, but I just wanted to refer to 2 authorities which I hope will explain better than I've done so far the exchanges in which I've tried to articulate the submission that access to justice consists in a matrix of factors. There may indeed be a wide range of factors which secure access to justice. I put it in the reply, in the, we had to do written replies because we ran out of time orally in the High Court. And that's tab 14, page 148 of the core bundle. The way I tried to articulate it at paragraph 5 is that access to justice can be seen as a dam made from an aggregate of various safeguarding elements, including a functioning system of courts, impartial judges, affordable court fees, access to and privileged communication.
Sorry, I'm not sure
so
where...
page 149 of the core bundle.
Oh yeah, got it. Sorry,
yeah. A whole range of components, privileged communication with lawyers, privately paid lawyers, legal aid, pro bono, etc. And some of those components are irreplaceable, i.e. but for some components where they might be removed, there's not necessarily a breach of access to the dam, but for some components there is. And in some cases, you can replace components. So I gave an example of legal aid being replaced by a pro bono scheme. So you can lose a component of that aggregate and replace it with something else, and still access to justice is safeguarded. And there are two authorities which illustrate that point, and they are a case of Leach and Howard League. So I'm just going to go to those to explain that concept further. Leach is at tab 5 of the authorities bundle. Leach is about a prison rule, Rule 33.3, which purported to permit prison governor to censor a prisoner's correspondence, and insofar as it included letters between the prisoner and his legal advisor concerning legal proceedings, it was held that that was ultra vires section 47 of the Prison Act. So one sees that at the head note at E through to G on page 37.
Is this the case where they found that the limit of the power was to check that the letter was related, was on a particular subject or wasn't on a particular subject?
I think my Lord has Daly in mind, which is the House of Lords, Lord Bingham's judgment in that case, but it's very closely related. So page 40 of our bundle, 1128 of the report, sets out Rule 33, and it's Rule 33 subparagraph 3 F to G that was in issue. Every letter may be examined, and the governor may at his discretion stop any letter or communication. And then at 46, 1134 to 1135, the highlighted passage, we turn to the principle of greater importance. It's a principle of our law that every citizen has a right of unimpeded access to a court. Lord Wilberforce described it as a basic right. Even in our unwritten constitution, it must rank as a constitutional right. Cites Raymond and Honey, that Lord Wilberforce said that there was nothing in the Prison Act that conferred power to interfere with this right or to hinder its exercise. And then at just below H, he went further than Lord Wilberforce, this is Lord Bridge, and said that a citizen's right to unimpeded access could only be taken away by express enactment. And at the top of the next page, equally clearly established is the important principle that a prisoner's unimpeded right of access to a solicitor for the purpose of receiving advice and assistance in connection with the possible institution of civil proceedings in the courts form an inseparable part of the right of access to the courts themselves. And then the discussion at 51. So Mr. Leach had brought proceedings in Scotland previously, which were addressed at at F to G, and Lord Caplan in the Scottish case had given judgment, and we see what he said at the top of 52. And in summary, what Lord Caplan was saying was that if you take away his correspondence, as long as he could see the solicitor, that would still safeguard the right of access to his solicitor. But that's rejected at D to E. The logic of this reasoning is that a rule which authorises a governor to withdraw the right to conduct legal correspondence entirely from prisoners would be lawful, provided the rules allowed prison visits by the solicitor. A prisoner can choose his solicitor, but he cannot choose his prison. If the prisoner is detained in a prison on the Isle of Wight, and his solicitor practices in Newcastle, the withdrawal of the prisoner's right to correspond with his solicitor could seriously impede his access to justice. We do not accept the submission that Lord Caplan's reasoning is applicable to the legal position in England.
But that was very much, this is old school. I mean, I know you're coming to it, but this is pre-video conferencing. So
Indeed.
It's letters or real people, the world we used to live in.
Yes. So the broader point that I'm trying to connect this to is this idea that there are a matrix of factors which safeguard access to justice. And so, although on the facts that's old school, what the court is finding there, Court of Appeal Leach, is that it's not acceptable to take away one component and say, oh well, as long as you can still talk to your solicitor in another way, you reach the same objective in the end, because they're saying there are different dimensions to correspondence and in-person visits which complement each other and together consist in the right of access to justice. So
it goes to the quality of the contact.
So yes, it's taking out part of that aggregate that comprises the right of access to justice and saying it's not simply enough that you could have done a workaround. The whole is what forms that dam in my metaphor. And there are certain components that maybe you can withdraw, but at some points the courts draw the line and say you couldn't remove the prisoner who is at the other end of the country the right to correspond. So the way it helps is not because obviously the technology's moved on, not on the facts, but on the concept that it's an aggregate. And just to round off that judgment, it's then 1141A to B on the next page. An unrestricted right to read correspondence passing between a solicitor and a prisoner must create a considerable disincentive to a prisoner exercising his basic rights. In our view, it creates a substantial impediment to the exercise of those basic rights. And the right to stop letters on the grounds of objectionability or prolixity means that access to a solicitor by the medium of correspondence can be denied altogether. In our view, Rule 33 is ultra vires so far as it purports to apply to correspondence between prisoners and their legal advisors. So that rounds that off. The next authority on this point, and this is the final one on this, looking at the real world matrix of circumstances, is Howard League, and that's at tab 15. So the Howard League case is 2017, it's just before Unison, so it's brought on grounds of fairness. It's about regulations made by the Lord Chancellor and whether the removal of legal aid would cause systemic unfairness in given classes of case. And it was held that the removal of legal aid did create systemic unfairness in some categories of case. So again, what it assists with understanding is that removing one component from the guarantees of access to justice, in this case legal aid, can breach the right of access to justice. Here it's legal aid, in other cases in Unison it's fees, in Anderson it's the ventilation rule, etc. So, if my lords and ladies have seen the head note, it's held, allowing the claim in part that determining whether the removal of legal aid from any category caused inherent or systemic unfairness depended on the application to the particular category of three factors: importance of the issues, complexity of the procedural, legal and evidential issues, and the ability of the individual to represent himself without legal assistance. So when one goes through this very long judgment, one sees that in certain cases it was considered that because of the inquisitorial nature of some of the hearings from which legal aid had been withdrawn, a person could represent themselves and not suffer a breach of the right of access to justice. In certain others, the combination of complexity, importance, and their own ability meant that it did create a systemic unfairness. One of the arguments, which we see at paragraph 9 of the judgment, page 331, was that there are compensatory safeguards which rendered the system capable of delivering fair decision making. That was one of the arguments for the defence there. So again, very much focusing on this idea of an aggregate of circumstances that need to be looked at.
Sorry, which paragraph?
Paragraph 9 is the summary.
Starting Miss Kaufman.
Yes, thank you. And then the key points to jump to them. Bear in mind this is a fairness case, not an access to justice, but it's closely connected. At 42 on page 337, the court would read that.
You've cited this in your scholarship, haven't you?
Yes.
Do you want us to go beyond 42?
Well, then, just to understand how it fits in, then over the page, the way the court approaches it is at 47, and they approach the question on the basis of the way in which the Judanovičian's case was decided, applying, as we see in the indented passage, whether legal aid is required will depend on, and those three factors are cited that we saw in the head note. No doubt my learned friend will deal with Judanovičian in his legal aid argument. And then at 56, the court finds on the first category, there are different categories at issue, but the court finds 56, halfway down, we consider that those with mental health problems are an appropriate sample category of vulnerable prisoners for the purposes of determining whether the claimants have established that the high threshold for inherent or systemic unfairness has been met. It was accepted that the prison population includes a disproportionately high number of prisoners with mental health problems. So, although this is a fairness case, adopting a similar approach of are there some in the cohort who would be affected. And then at 91, it sets out the evidence of the parole board suggests that although the board is designed to be inquisitorial, its procedures, even when adapted to deal with unrepresented prisoners, are given its workload and resources not sufficient to ensure effective participation without deferrals and serious delays to hearings. The board staff find it difficult to keep unrepresented prisoners informed of developments about their cases and to seek their views, and there are practical barriers to assistance by offender managers and from other sources. The result appears to be a reliance on ad hoc arrangements, in particular cases after things have gone wrong, such as securing assistance from the bar pro bono unit rather than a system. 106 sets out expert evidence can be crucial, and 109 explains that in our view the removal of legal aid from the Category A review process has resulted in an inherently unfair system, because decisions as to classification or continued classification of a prisoner as Category A are important, which affect the liberty of the prisoner in the sense that they materially affect his or her prospects of release, even if they are not directly determinative of release. The reviews involve the assessment of risk, which can be complicated. And 3, the alternatives that exist in the prison system and outside it that are identified and relied on the Lord Chancellor to fill the gap do not provide sufficient protection in practice for those prisoners who are vulnerable or have learning difficulties or suffer from mental illness. And so that metaphor of filling the gap harkens to the image I was trying to form of there being an aggregate of matters that create a kind of dam for access to justice. And you can take a component out, legal aid, and put pro bono legal assistance in, or take out legal aid and put in inquisitorial processes to fill the gap. But they find on the facts in relation to a cohort of mentally ill prisoners that it doesn't. Those safeguards, those backups didn't fill the gap. So one has to look at the matrix of factors overall. And so then 146 is the concluding paragraph of this judgment, we emphasise that we recognise that there may be safeguards other than legal aid and advice that will prevent inherent or systemic unfairness by enabling a prisoner to participate effectively in a category of decision making. The government's decision to remove legal aid from the 5 categories of decision making that are the subject of these proceedings by the 2013 amendment regulations was made because it considers that there were adequate alternative means in place to ensure prisoners can participate effectively in areas in which support has hitherto been provided by legal advice and legal representation. The consequence is that almost no changes have been introduced to replace the gap left by the removal of legal aid. We have concluded that at a time when the evidence about prison staffing levels, the current state of prisons and the workload of the parole board suggests that the system is under considerable pressure, the system has at present not got the capacity sufficiently to fill the gap in the run of cases in those 3 areas. So I hope that illustrates, albeit in a fairness context, the analogy I'm trying to draw, that one has to look at the overall matrix of factors and whether the gap is filled.
Can you just pause a second? Yep, thank you.
So I turn then to the evidence in this appeal, and to start with, summarise why we say that removing, in practical terms, the access to or availability of in-person legal visits acted as an impediment to access to justice. And in summary, 6 points. First of all, some women, indeed a significant proportion in detention, are particularly vulnerable, entailing particular needs, complexity of legal issues, and complexity of communication. Second, communication problems can be seen in 4 subpoints. Technological difficulties, firstly. The need to read body language, secondly.
Hold on. Communication problems can be seen in what?
First of all, I'll bring on to the evidence technological difficulties, so
Yeah.
the feed cutting out and not being able to hear over the phone and so on.
Second.
Secondly, reading body language. A number of the deponents refer to the importance of that. In difficulties with interpreters and language barriers.
Thank you.
So my third heading, so that was communication, my third heading is building trust and rapport, a number of the components to talk about. Fourthly, disclosure, difficulties for vulnerable women in disclosing experiences such as trafficking and sexual violence. Fifth point, particular problems for the disabled. And sixthly, difficulties for solicitors assessing how a client may appear as a witness. So I'd pick up the references in the evidence which support those 6 headings. So first of all, the women in immigration detention are particularly likely to be vulnerable and may be survivors of domestic violence, sexual violence, FGM, trafficking. See Dr. Loosley, Supplementary Bundle 249, paragraph 6. The second factor which compounds that vulnerability is that detainees' legal claims are likely to be urgent. So concerning issues of urgency such as imminent removal, detention, trafficking, past trauma.
Sorry, the problems are likely. You're still on your first point.
Yeah, so this is the vulnerability of the
Particular
client.
complexity. Is this what you're talking
This
about?
is the vulnerability of the client.
Yeah. So forgive me, I'm just
That's the first
slightly lost the track. You gave us paragraph 6 of
Yep.
loosely, which we've looked at, and then your second reference is
So that's just one point, just that paragraph, but that's the explanation, is that those are the vulnerabilities the women have, but the extension of that is it follows they have particularly urgent issues such as imminent removal and detention combined with that. And one place that these kinds of issues is well articulated is in the Equal Treatment Bench Book, which I'm sure the bench will be familiar with, but it's an extremely lengthy document, so we've excerpted from Annex E to that. We could hand those copies up.
thank you.
This is the February 21 edition, April 23 revision.
Thank you very much.
And it deals with remote hearings. So it's obviously in the context of hearings rather than taking instructions, but one can see that the analysis and the advice given to the judiciary may be of some relevance here. And we draw attention in particular to paragraphs 17 to 23 under the headings difficulties for disabled people and difficulties for people without English as a first language. Nothing more to say on that other than to draw it to the court's attention.
17 to 23.
Yes, please. And you bring that in really because it's more of an objective recognition of some of these issues which most of the witnesses speak to in their evidence. So reason 2 is the communications being compromised. So remote communication erecting a barrier to verbal and non-verbal communication. And I said there were 4 subheadings here. First of all, technological problems, cutting out, poor quality, making communication more difficult, slower. And I'll just give the references rather than turn them all up, but it's Mr. James Wilson's evidence, SB 247, paragraph 15. Ms. Parrott.
Hold on. James Wilson wasn't on your list, so can you give me that again? James Wilson, SB
247,
yeah.
paragraph 15, and then Ms. Parrott, SB 207. I know I will take the court to that because it relates specifically to SPM, paragraph 43 to 44. She talks about the poor mobile phone reception, getting cut off.
Hold on.
So Mr. Wilson, you referred us to
Paragraph 15,
right.
247. Is that right?
What's that got to do with Derwent side? I mean, it may be right, but what's it got to do with Derwentide?
Well, he's concerned about telephone signals being a barrier to effective communication. So he's indicating.
I thought the evidence was that high speed connectivity had been introduced at Derwentide. I mean, this is just a general statement about, you know, having dodgy mobile phone signals in rural environments or remote parts of the UK. I mean,
Yeah. So what happens, as we've seen just from the evidence we went to, is that the initial call, so the 30-minute call, is made to detainees on a mobile phone in their rooms.
yeah.
So that's the DDAS 30 minutes that we're concerned with. And so we see here and in Ms. Parrott's statement that their experience of trying to conduct phone calls to these detainees is poor mobile phone reception and being cut off.
What, to these detainees in Derwentide?
Yes, so to SPM herself is the evidence at 207.
Okay, but paragraph 15 of Mr. Wilson is just
It's
a
more
general,
general,
a general paragraph.
Well, 16 is about DDA at Derwentide. I mean, but it is true, that is more general, I agree, yes.
But it doesn't say,
I accept that.
it doesn't say, it's not a follow-on from 15, it's not saying...
Agreed.
Right, okay.
I accept that. That's a more general comment.
Sorry, and then the next one you were going to...
The next one is SPM, and that's at 207.
You've just taken us to paragraphs 33 and 34.
So 43 and 44.
43 and 44.
At 206 to 207.
Yep.
And Ms. Parrott says, in the first few days of our instruction, there were several instances where there was a poor phone mobile reception and SPM and I were unable to continue our conversation or the phone cut off entirely. This happens when she is in her room, which means that she has to leave the privacy of her room in order to speak on the phone with me. When this happened, SPM would call me back shortly later, presumably when she'd gone to a different part. Practical obstacles. Further, due to the multiple barriers faced by SPM, she requires face-to-face attendances. In particular, she struggles to hear on the phone due to her hearing impairments. Further, English is not her language, so she sometimes does not understand what I'm saying. Her hearing impairments and limited English understanding compound one another. It's very difficult to understand why she cannot understand in a given moment. I've done my best to compensate using speakerphone, speak slowly and simply. Not best practice, does not allow for proper client care. And then the next reference was another illustration only, paragraph 92 of Dr. Loosely's evidence at 267 to 8.
Page, sorry, 278.
267 to 268, paragraph 92 of Dr. Loosely's statement. Then the next point, sort of sub-point under communication, was the body language point, i.e. that visual and non-verbal cues are likely to be lost by the use of remote communication. And we can see that, for example, in Ms. Patel's evidence, SB 231, paragraph 50.
Sorry, I'm really bored.
SB, Supplementary Bundle 231, Ms. Patel, paragraph 50. From experience, it's unquestionably easier to get more detailed instructions when dealing with a client face-to-face, especially for clients who are vulnerable and are suffering with mental health issues. It's also highly relevant for less vulnerable clients. The ability of non-verbal communication to explain how a client is feeling, whether they feel comfortable enough to divulge further information, is a key component in building a relationship of trust. I know whether a client is in a position to provide more information from their body language, and I know when to stop trying to obtain further detailed instructions if a client shows clear signs of distress. That's also a point picked up by Dr. Juliet Cohen, which is at Supplementary Bundle 277. So 276 to 277, paragraph 12. So that's second subpoint. The third subpoint under communication is interpreters. And that's a point that's drawn out by the bench book, paragraph 23. That document I handed up. It observes the difficulties of having interpreters in different locations. And it's a point picked up by Dr. Cohen at paragraph 10 of her evidence on the previous page, 276, the Supplementary Bundle 276. She says, remote contacts limit non-verbal communication, which is an important element in developing rapport and in understanding when a person is distressed, suffering intrusive memories or having a flashback. If the connection is by telephone only, then communication is even more limited. The additional requirement to communicate through an interpreter, which is the case for the majority of immigration detainees, makes remote assessment even more problematic. And then the fourth subpoint under communication was language barriers. Most women in immigration detention don't speak English as their first language. So when an interpreter is not available, as we've just heard from the evidence in Ms. Parrott's statement, that's another impediment to communication, which we've already seen in Ms. Parrott's statement. I don't go back there for that point. Okay, so that's communication. So then my third heading.
If all other things were equal, I'm not sure why that makes the big difference between in-person and video conferencing.
If the interpreter were remote in either instance, it would have...
No, you just gave us the language barrier.
Sorry, the language
additional
barrier.
one without an interpreter. So you've got two people without an interpreter.
Yeah.
What's the difference between an in-person and a video conference?
So ordinarily, my submission would be it's easier to speak a foreign language and to communicate in a language which is not your fluent or first tongue when you can see the person face to face and understand the receptivity to what you're saying than it is over the telephone.
I asked you about video conference, not over the telephone.
Sorry. Similarly, over the telephone, over the video, that... But
not similarly, that's exactly the point. I mean, I understand why telephone might not be quite so good because you don't visually, part of understanding may be visual in terms of understanding somebody's expression or how they're speaking. But I'm struggling at the moment to see the difference between a video conference and in person if the question is simply language.
Yeah. Well, I don't want to go stray beyond the evidence I've taken, my lord, too.
Right, okay.
But
is there something on sorry, was there a piece of evidence on language that you've taken us to? Because I haven't marked anything down yet.
On language? No, I've taken you to a passage in Parrott's evidence about the difficulties of knowing whether it was the hearing problem or the language problem in any given instance. And
What was that Parrott 43?
Yeah, that was all I was going to pick up on that. The difficulties, probably the best place to turn to answer my lord's question is the bench book, the equal treatment bench book on difficulties for people without English as a first language. which does seem to accept, at the fourth bullet point, that there are fewer visual cues to assist understanding in remote hearings.
Sorry, which paragraph are you in?
22. Pointing to things, drawing things, those sorts of visual cues. There are fewer when using remote access.
It's the last three buttons, isn't it? The last three buttons.
Yes. Yes, of 22, yes. And similarly, 23 and the same sorts of points are made about interpretation, which we've dealt with. So that was my second reason, communication. The third reason about why face-to-face legal advice and communication can be an essential component of the right of access to justice is building trust and rapport. And that's particularly important in the context of this cohort because of the need for disclosure of traumatic experiences which female detainees have often undergone, and that being key to the question of the lawfulness of the removal, which they would ordinarily be facing, and indeed to the question of the lawfulness of the detention. And the evidence suggests it significantly, well, the evidence suggests that in relation to building rapport, in-person, face-to-face meetings are essential, and that word is used. First of all, in the evidence of Mr. Hussain, supplementary bundle 43. Paragraph 80 in the conclusion, third sentence, it has been my experience and the experience of those in my team that face-to-face legal advice in immigration removal centres is essential for certain individuals to ensure a trusting relationship is built and difficult information is disclosed. So not preference, but essential. Dr. Cohen at SB 283.
Sorry, just two questions. One, does he actually, this is a conclusion, does he actually deal with it in more detail elsewhere, or is it just, does it just pop into his conclusion?
Yeah, so he sets out in section C, so that's page 23. Sets out the nature of the claims. So, and then he provides a series of factors throughout the statement, but starting at 24, he says, these 30-minute initial advice sessions do not provide enough time to recognise the most vulnerable claims, including victims of torture, trafficking and exploitation. The indicators are not always obvious. From my own experience and the experience of colleagues for whom I've spoken, it would be definitely be easier to pick up on hesitation and to disclose if you're face-to-face with a potential new client. 25, key requirements about the setup.
We're just pausing there, just to go back to an old point of mine. Just a bit troubled that what he's really saying is it's always difficult. So 30 minutes, what he says is 30 minutes isn't really enough in the best of circumstances.
Yes.
And doesn't your case need to show that it's the lack of efficacy is consequent on the lack of face-to-face? And really, it just seems to me that every time we look at your case, it seems to get bigger and bigger and bigger and bigger. It's everything is bad, and it's all leading to this situation where these vulnerable people don't have appropriate legal support. And in a sense, that's just too big a case, isn't it? That's not the case you're running.
But, well, no, that's not the case we're running. That's why I try to use this metaphor of
The dam.
removing a key brick from the dam,
Yeah,
or a tipping point.
Paragraph 24 doesn't remove a key brick. It says that there's not enough time, even in 30 minutes, in the best of circumstances. And that's the problem, is that we're not looking at bricks, we're looking at the whole dam.
But our position is, with the whole dam, with Jarl's Wood, no one ever brought a challenge to an infringement of access to justice in the circumstances that contained there, because the whole dam was there. The tipping point came when it was moved to Derwentside with all the attendant circumstances. It's not any individual one of those, it's the combination of factors. Principal among those was no longer in person, but also included that there were no charities and support networks as had grown up around Jarl's Wood, and so on. So there were various other factors which were also no longer there as compensatory safeguards, which is how the argument was put in the Howard Lee case. They said, well, we're taking legal aid away, but staff at the prison will help. But that wasn't what happened here. They not only took one component away, they took other components away. Sorry, my lord.
Sorry, no, I interrupted you. I'm sorry. But was the lack of compensatory safeguards, as you put it, I also know support, other forms of support network, how was that put to the judge?
In the same way as I'm putting it now. I read out my...
Are you going to go to the evidence on that? I mean...
Oh, the evidence on parts of the network and so on, from Women for Refugee Women, and yes, I mean, there's evidence of that, but yeah. What I'm trying to show is that what may appear to be a nice and precise distinction is actually one which did tip the balance, which did break the dam.
Because I think that is what you need to show. I think you do need to demonstrate that, not that the evidence shows this was all very difficult, and by removing in-person contact it became a bit more difficult. I think you need to show that it made it so difficult that it took what was effective into being ineffective. And it's the factual differences which are specific to Derwentside that you need to focus on. And just at the moment, one of my problems with your evidence is it seems quite generalised, and I have struggled to find something very specific to those circumstances that make the difference. Because what I see is lots of solicitors saying it's very difficult, these people are vulnerable, they don't speak the language necessarily, you can't always get the interpreter you want, and they don't want to disclose for reasons I entirely understand. But where is it that it said that if I had 30 minutes with them in person at Jarl's Wood, I think they would have disclosed, but because I've only got 30 minutes with them over the video conference thing, they haven't. Do you see what I mean?
Well, let me take my lady to the passages that there are that approach that. SB 283 is Juliet Cohen, and paragraph 20.
My 283 is 27.
Oh, you're right.
See, but just before we leave page 24, but to pick up my lady's point, I mean, in paragraph 25, I read 25 as saying, he talks about, quotes, given these expectations, which you like are a sort of shopping list of what's the most desirable, the key requirements talk about, at C, having the choice of being able to see the client in person following an initial advice session. I mean, it doesn't seem to be an expectation that it's the first 30 minutes which makes the difference. In other words, to pick up on my lady's point, is it really, do you not need to show that if the first 30 minutes are in person, you can pick up the problems, but if the first 30-minute session is by video conference, you can't, or at least there's a real risk of that being the tipping point, the difference.
Well, again, my lord, I don't need to hinge it on that nice distinction, because what's also evident was that the next 30 minutes or the next hour was not available in person either. And so if the reality is it took 2 visits in person to secure access to justice, then neither 1 visit nor 2 visits was available because of the remoteness of the distance. So it's not all just about this 30-minute session. As we've seen from the evidence, the 30-minute session is a triage type of session.
But I thought at the end of that session, if there's going to be a follow-up, you move on to a different charging structure, which is more which is, as I understood it, I'm not sure whether we have seen the evidence actually, but the assumption is that it's more cost effective and potentially profitable than the DDAS 30-minute sessions.
The assumption was that the case as a whole might be the evidence of Ms. Patel, which is about the travel times and travel costs, is that it was not viable for her firm to, even at that juncture, allow a solicitor to travel 5.5 hours from whatever the round trip would be from London or Leeds and back again and do more than a full day's work in order to meet in person. So it may well be viable to take the case on and do more work remotely, but the travel costs and travel time are adverted to in the evidence. So it's that combination of barriers which is then reflected in the fact that nobody went there in 6 months. We've seen there's only six visits in the 6-month period. Anyway, before I leave Mr. Said's statement, I hope that explains, and then 80 is his conclusion on the basis of all of the various factors. Some of them I accept it would be preferable, he puts it in those sorts of terms, but his overall conclusion, having looked at them all, is that face-to-face legal advice is essential for certain individuals to ensure a trusting relationship is built and difficult information is disclosed.
The difficulty I have at the moment is understanding how that follows from what is described as the, quote, snap decision, which has to be made in the first 30 minutes. I know you say we're not focused on the 30 minutes, but in essence, that's got to be a focus, hasn't it?
It's certainly an important part, because it is, for the majority of people who were detained, the way in which they accessed a lawyer. In SPM's case, it wasn't. She wasn't able to organise a duty solicitor. She got in touch with Duncan Lewis through a charity. That illustrates one kind of example where the 30 minutes is not relevant.
But then we come to a difference between a structural failure, which is what you've been concentrating on, where you've been talking about the factual matrix, and the factual matrix includes that, as it was set up then, there was a 30-minute DDAS initial interview, which was by default was by telephone, although video conference was available, and if face-to-face was available, it wasn't being accessed by people in the vulnerable cohort. That's a structural position. And what one might call an operational problem, if you were saying, bringing a claim on the basis that although that was the structure, it wasn't being operated properly for your client. And it seems to me they're two completely different things. And you're running a structural case. So
that is right. The fact that my client happened to be unable to access it is not a key component of this argument.
You're saying you could almost take your client out of it. I don't mean any disrespect to her, because on the submissions you've been making this morning before lunch, you were saying that it would be sufficient, her detention would have been unlawful if there was a significant risk of lack of access for other people. Because you're running a structural case, as I understand it.
That's right.
So, although we obviously keep your client very much in mind. In a strange sort of way, and I don't mean any disrespect to her at all, I hope she will understand, she's not central to your case.
Save insofar as we have the most detailed and accurate evidence of the way in which it in fact operated
Yes.
in her case.
Yes.
So, but her case is illustrative rather than...
She is a member of a cohort.
Yeah.
Who I think at one point this morning you said you were representing, but I don't think you're formally representing.
I think that was put to me rather than what
Okay.
I said.
All right.
But
But
I don't obviously
But
represent
you are
anyone
here
other than my
simply
client.
representing her,
Indeed.
presenting a structural case based on risk of lack of effective legal access. Well, at least I think I've got that right. Thank you.
Grateful. And shall I continue with some of the evidence which I was
Go,
trying
yes, please
to
do.
take the court to? It's paragraph 20 of Juliet Cohen's, which is at 280. I think I may have given the wrong reference before. Page 280.
Are you going to go to Shalini Patel's witness statement mentioned in paragraph 24 at some point or not?
I wasn't proposing to, but I will do at my Lord's request.
Well, only just because there's a reference to it in the paragraph you did take us to.
Yeah, there is. That's right.
And in a sense, that you took Mr. Hussain really seems to be almost just giving indirect evidence.
Yeah. So, well, I think he was trying not to repeat what had already been said.
Anyway.
So 20 of Juliet Cohen's, Dr. Cohen's, for female detainees who are unable to build sufficient rapport to disclose all of their experiences, there may be very serious consequences. It's well known that experiences, particularly of sexual violence, may be difficult or impossible for the individual to disclose, and disclosure may be delayed for long periods, for many years, even in the UK. And at 21, well, then she explains various other factors, stigma, etc. And then at 21 says, a relationship of trust and a good rapport are essential for these disclosures. A woman has to feel that what she discloses will be safe in the hands of the person to whom they give the information. And much of this necessary assurance is conveyed non-verbally by gesture and expression, which will be lost in a remote connection. It's not unusual in my clinical experience for a person to disclose some of their experiences late in the assessment or only on a second appointment. And this is an indication of how the development of rapport...
Is she there talking about in-person assessment?
Yes. So she is a medical expert. She's
Yes.
but she is talking about disclosure in the course of in-person meetings. Yes.
Thank you.
And so that was the reason I went there, was to go back to my lady's question a few minutes ago as to the distinction required between remote and in-person. And here we see a fulcrum point as described by Dr. Cohen, in which the rapport, as she describes, being conveyed non-verbally by gesture and expression, is achievable only through the in-person meeting.
As I see it, she's saying that it sometimes, and I entirely accept this, that sometimes it takes more than one meeting to get to the bottom of what's going on. And one can, I think, take it that there may be some individuals for whom even 2 or 3 or 4 meetings aren't going to be enough. And some people never make disclosure because it's so exquisitely difficult for them to be able to articulate it. And that's what we're dealing with. But I keep circling back. The challenge, I think where you need to be is to demonstrate that there is that there's a lack of a reasonable risk of a lack of effectiveness just because of the mode of the original way of having your the original meeting, the DDAS or whatever it's called.
But my lady's example demonstrates how the remoteness of the location, which is one of the key factors, in fact multiplies over those multiple visits, because when it's at Yarl's Wood, it's an hour on the train from central London. It's very easy to make the multiple visits, and a good solicitor will think, she hasn't quite fully managed to disclose. When it's an unviable 11-hour round trip to Derwent's, to make that multiple times multiplies the unviability of it. A good solicitor may think it's worth the loss, that's part of my duty, but to do that multiple times is a clear example of when the remoteness
in geographical
tips the balance
terms. Yep, okay.
in geographical terms into it being impossible, to use the word of Dr. Cohen, for the individual to build up the rapport and therefore for the access to justice to be facilitated. And closely related to that idea of rapport is then the disclosure that comes through the rapport. That's my fourth point.
That's going to be the same evidence, isn't it?
It's similar evidence, that, but I'll just take different references to fill out the picture. So SB 255.
Yeah, although, just to be clear, the word impossible was used by Dr. Cohen, but not in the context that you use it.
Sorry, she uses essential in 21. Top line of 21, a relationship of trust and good rapport are essential for these difficult disclosures.
Right.
And at 20, it may be difficult or impossible for the individual to disclose.
Yes, but to pick up my lady's point, if it's impossible for the individual to disclose, it doesn't matter how many sessions you have of whatever nature, it's not going to happen.
No, that's not the point that Dr. Cohen's making, respectfully. It's that...
But that was the context in which she was using the word impossible, which is why I picked you up on it.
The point that I should have said the word used is essential in that context of my submission. A relationship of good trust and rapport are essential for these difficult disclosures, and difficult disclosures are essential for access to justice. Paragraph 30 of Dr. Loosley's evidence at 255. And 31. Under the heading 30 to 31, the importance of in-person legal advice for facilitating disclosure. We are extremely concerned by the lack of in-person legal advice at Derwent's side. It's our experience that speaking with women face-to-face is critical to building rapport and to developing a relationship with them, so that they feel able to trust the person they're talking to and open up about previous experiences of rape and other gender-based violence. So the word critical is used there. And that same word comes up in the statement of Ms. Patel at 215.
So, is the logical consequence of this that your case would only be satisfied if the Secretary of State ensured that there were limitless, as necessary, limitless in-person interviews to enable a vulnerable woman reach the point where she felt that she could disclose difficult things? It's pretty close to it. I mean, we're concentrating on the first 30 minutes. But the evidence you've just shown us, which obviously is in a clinical setting, and like my lady, I can completely understand and readily accept that people who are traumatized, who've had the sort of life experiences that we're told your client has had, may in a clinical circumstance where the whole thing is set up with absolute expertise of medical professionals to gain the trust that will enable people to disclose their traumatic background and come to terms with it. Has that got to be replicated in the detention context?
Well,
for there to be effective legal advice?
in a given client's case, one would need to ascertain, on the basis of the factual circumstances, what was essential for access to justice to be obtained. So a person like my client finds herself in detention. What she needs to be able to achieve is to disclose enough that her solicitors are able to obtain her release and to stop the removal. But the process of actually fulfilling the full evidence of her experiences is subsequent to that a lengthy one. So there are numerous occasions on which my instructing solicitors and my client will have met in order to prepare evidence towards the trafficking claim as a whole.
So are we concerned with the first DDAS interview or the whole sequence? Because if we're concerned with the first, then at the moment, obviously we'll all go away and we'll look again at the evidence. At the moment, it seems quite a stretch to say that the absence of in-person first interview, almost as mandatory, makes the difference or creates the risk that a competent solicitor won't realise he's got a complex case on their hands.
I think
I
think perhaps my learned friend's argument has caused much of this confusion.
Possibly.
I have not suggested at any point in my submissions today that I invite the court to look at one component of the access to justice matrix. So the court is not being invited, as far as my submissions go, to focus on the adequacy alone of the 30-minute DDAS appointment.
Well, your ground of appeal, for which you've got permission, is that the appellant had used extensive evidence which demonstrated that remote-only communication was inadequate, especially, well, you know the terms of your ground of appeal. And then secondly, the judge was required to apply anxious scrutiny. So those are the two limbs for which you have permission to appeal. Now, I think in the course of your submissions, if I've understood them correctly, and again I'll go back and look at them again later, we've established that there was no prohibition upon in-person meetings subsequent to the first DDAS meeting, although you say it just didn't happen, and you've pointed us to the evidence of people who say they didn't know that it could happen. I go back to what I was asking about structure. We've got a structure which involves an initial DDAS interview by default. What else on the grounds of appeal are we looking at? Because that's the only remote-only communication that we're really dealing with.
All the communications between solicitors and clients, with the exception apparently of 6 visits in a 6-month period, were remote, whether on DDAS or otherwise. So, for example, my solicitor's communication with SPM was not a DDAS communication, it was remote. The ones that are spoken to in Ms. Parrott's evidence. So focusing on DDAS misses out the full picture. It's part of the picture, an important part, because it is the system by which the Secretary of State hoped to discharge the responsibility for ensuring access to justice. We see that in the Equality Impact Assessment before it was set up. That's what they assumed would happen and hoped would happen. So it's an important part because it means that at least at the level of a right, everyone has an opportunity to see a lawyer. But it's not the only way in which lawyers communicate with clients. See my client's case. The remote-only nature of it is a consequence of a series of factors, primary amongst which was the transfer from Yarl's Wood to County Durham of the detained female population.
Mm-hmm. Thank you.
So that's why the challenge is to that exercise of the power under paragraph 18 of Schedule 2, the power to designate a given location as a place of detention. We say that's to be read subject to common law right of access to justice. Parliament didn't provide any express words overriding that, and so was not to be exercised inconsistent with that. And as I've tried to emphasise, there are many ways in which it could have been exercised consistently. One of them, and the obvious one, would have been to have guaranteed face-to-face appointments. But there are other options, as I've talked about, And that's why one looks at this full matrix in the Howard League type approach, that there are other ways of compensating for the problem that might be created by a particular manoeuvre.
Just pausing there for a moment, just to pick you up on that submission, or at least to check I've understood it correctly. Just before we do, by the way, I think paragraph 32 of Loosely actually is significant. You took us to paragraph 31, but over the page 32.
I've forgotten the reference now. Was it?
Page 256. You took us to 255. It's top of 256. You see, because I think if the focus is now shifting from, or you say it never was on, the first 30 minutes, in other words, you say it's no part of your case to focus on the first 30 minutes. The point is that face-to-face meetings, however many, are what is required to alleviate the risk, or minimise the risk, however you'd said it, of not detecting particularly vulnerable clients.
Yes.
I mean, what your case sort of amounts to, picking up your comment that what you need to do is to guarantee face-to-face visits, which I think you saw expression. You're basically saying that Derwent side should not have been open for operation unless and until there was a support network in place for face-to-face visits with the detainees. And if that required payment of additional monies to make it financially viable for sufficiently experienced lawyers to travel from where they were currently located to Derwent side, that's what would have had to have happened. But if it didn't happen, the detainees shouldn't have been transferred from Yarlswood, which was where they were supported by people who found it economically viable to travel to the prior detention centre.
Yes, to the extent that that is one solution that.
Yeah, I'm picking up the solution you gave us.
But as I've kept emphasising, a large pro bono scheme by a big corporate firm based in Newcastle.
It would still need to be face to face. That's the point.
Would also supply the gap of face to face. Yes.
So it needed to have. So I think, is this right, that absent face to face legal support at Derwent side, you say that it was not permissible to move any women to that facility because to do so would breach their constitutional rights or their common law rights.
I don't want to put it exactly like that, Modi. I'm sorry.
It is that, but we've been around this block several times now, and I'm sorry I was with you before, but I think we do need an answer to this, because I really do understand, I think, how you put your case. You don't want to put it this way, but it is the flip side, isn't it? If you say that there is a real risk of breach by putting women at Derwent's side in circumstances where they don't have face-to-face support from lawyers available, and that to do so is false imprisonment, it must follow that they can't be put there.
But what I don't want to suggest is that there's only one way of achieving an access to justice compliant form of detention. So, for example, there is a detention gatekeeper system for families who are facing short periods of detention, whereby the detention gatekeeper goes and meets the family prior to the short period of detention, ascertains any vulnerabilities in a residential setting, and tries to work out a more sensitive way of ensuring the removal of that family back to the country of origin. So there may be other solutions whereby you filter out the vulnerable people, or the majority of them, before you ever get to detention. There may be other solutions for ensuring once they're there that they have the support of face-to-face people. It may not.
But these were people these were women who I think were all in Yarlswood already. They were already detained, weren't they?
SPM was detained for the first time at the end of January in Derwent side. So some were moved, but new people started to come in as Yarlswood closed down and Derwent side opened.
Okay, but the same point still arises, doesn't it? That without the facility for face-to-face meetings support from either pro bono, people on station to offer pro bono advice that would have to be suitably experienced, or suitably experienced commercial paid practitioners who were properly remunerated to go, such that it would happen, you're saying people should not have been located there, should not have been
on the given
should not have been detained.
Yeah, on the given set of facts that happened, that is my argument. But what I'm not going to concede is that the only way of remediating the problems that were in situ in the real world was to change that one factor. What I'm saying is, yes, that one factor, face-to-face meetings, would have changed it, but there are other ways that it could have been done. So there are compensatory
but we know that the other ways
be used.
weren't done.
Yeah, but in the
and have not been suggested as a possible alternative. So you are left with saying, because nothing else was done,
yes,
this was unlawful.
yes.
But the logical, I understand your point, is you say other things could have been done, but nonetheless, in the absence of other things being done, the individual should not have been detained there.
Yes, that is my argument. In the absence of other things being done, the absence of the face-to-face legal visits meant that the individuals shouldn't be detained there.
And I don't want to put, I'm deliberately not talking about your client, but if one just takes a notional detainee, it does not matter to that argument whether they were themselves part of the most vulnerable cohort or not.
My Lord, in the absence of other things being done, as my Lord just put it, it does not matter, because in the absence of other things being done, the Secretary of State had no idea whether the person was part of the vulnerable cohort or not. If other things had been done and had filtered them out before they went in, maybe the position would be different. But in the absence of other things being done, it makes no difference, because the risk is that any given individual could be in the vulnerable cohort.
Problems for the disabled?
Yes.
Well, I wouldn't want for one moment to blow you off course.
I will just pick up the last two references. SB 108.
Is this still
I was on
disclosure?
Patel 215. Was there anything to be done with her?
Oh, did we skip that? Sorry, that was in fact intended to be 275. I misread my handwriting. Sorry, that was 275 Patel. Paragraph 9. Disclosure, in-person legal visits have important and critical advantages over remote contacts, whether by telephone or video link. At an in-person assessment, it is far easier to establish trust and rapport. This is needed in order to facilitate difficult disclosures. Difficulty in disclosing experience of sexual and gender-based violence and other forms of abuse are well recognised. Many people delay for long periods, although disclosed, but such disclosures are critical for a person who has had these experiences in order for them to articulate their claim for asylum. So that's the critical nature of disclosure. SB 108. Dr. Loseley, paragraph 15. Second sentence, I continue to be of the opinion that access to face-to-face legal advice for women who are detained there is essential. So this is picking up some of the point about preference that not all the evidence goes to.
What page was that?
108, paragraph 15 of Dr. Loseley's statement.
Thank you.
SB 273.
I mean, I have to say, of itself, paragraph 15 doesn't really do it for me, because it just is pure assertion. I don't know what lies behind it.
Well,
I mean, okay.
let's leave that, and I'll leave my
Right. Yep.
my Lord to.
SB 273.
Yes. paragraph 5, Stuart-Cohen again. The provision of in-person legal visits is essential for two linked reasons: for the mental health of this vulnerable group and for them to be able to make sufficient disclosure. And then 284, again, Dr. Cohen, final paragraph: in my opinion, any immigration removal centre needs to have in-person legal advice readily available for the population of detainees who will pass through. Women are known to have a high prevalence of past experiences of sexual and gender-based violence, which adds to their vulnerability and need for safeguarding for the reasons discussed above in terms of their mental health, difficulties in disclosing past experiences, and the impact this may have on their healthcare and application of asylum. The need for in-person rather than remote appointments in terms of facilitating best trust, rapport, communication and disclosure, as well as managing distress flashbacks and potential crises, are clear. In-person appointments are essential for safety and for access to justice.
I mean, with these questions, I mean, this is an expert witness. Yeah. The questions, were they framed by your lawyers, or were they questions agreed to by the Secretary of State?
They were framed by my instructing solicitors. It's not a joint expert.
Well, no, I appreciate it's not a joint expert, but that doesn't stop the questions being agreed. I mean, the questions are, I was hesitate to say loaded, but the questions are somewhat suggestive of the answers, aren't they? I'm not saying that the opinion of the expert isn't, the opinion she genuinely held.
No,
but I was just curious to understand how the questions came to be put in that way. But it may be that there's no rival expert evidence, so maybe.
Well, there's no rival evidence on any of these components of in-person, face-to-face meetings from the Secretary of State. The Secretary of State does not contest by evidence any of the evidence of the experience of in-person or face-to-face meetings.
So.
The other point on...
just for a moment, none of us said anything.
I think there's the hearing loop.
There was a feedback from my client's hearing. Final reference I want to make on difficulties in disclosure is to the modern slavery statutory guidance, which was referred to below. I think we've brought a copy of that along, or is it in the... Oh, it's in the authority's bundle already, apologies. Which is the final tab there, tab 20. So this is the respondent's guidance. You see it at page 600 of the authority's bundle. And then 602 is the barriers to disclosure. Explains it's unlikely a potential victim will be able to explain their experience until they've achieved a minimum level of psychological stability. A delay should not be viewed as manipulative or taken to mean these facts are untrue. The late disclosure of these facts may be the result of an effective recovery period and the establishment of trust with the person to whom they disclose the information. Disclosures often come slowly and in a piecemeal way, sometimes over years. So just some recognition in something outside the framework of evidence of the basic points that have been adverted to by those experts and solicitors involved in the field.
Mr. Goodman, can I just ask a question which has been just troubling me in sense of the background? These women were detained pending deportation, is that right?
Well, it's the word used in the statute is removal.
Removal.
Yeah.
And just give me a sense of their background. Some of them would be overstayers, failed asylum seekers, people who committed offences, so people with
So,
criminal records?
so those who've committed offences are usually facing deportation.
Okay,
That's
would they be here, or are they a different
So they
lot?
could be here, yes.
Yep.
Yeah. So it could be people who failed to regularise their status following the withdrawal from the European Union.
Yeah.
Lots of people from Eastern Europe are in that position being removed. It could be, yeah, as my lady says, overstayers, people who've claimed asylum and failed, people who've been trafficked.
My point is only this, and I don't say it in any loaded way at all, but these are people who, by and large, have been in the UK for a period of time, and they have had proceedings before. So that some of them will have been through tribunal
Some will, yeah.
claims, criminal proceedings, so on. So what we're postulating is a group of people who have not at any previous stage made the disclosure, because your hypothesis is they wouldn't be there if they had, because that would all have been looked at, and if they had a right to remain here, that would have been dealt with. So, for example, if they were victims of trafficking, they would have been referred at a preceding stage. So these are people who haven't made disclosures, if they have disclosures to make, at any stage in their preceding history.
Well, so again, that's an example, but if I go back to SPM's case as an illustration, because we have the evidence, she did make the claim in her asylum appeal. The judge said, well, there's no medical evidence. I find that surprising.
Okay.
It was only when she got to the detention centre where a medical examination was undertaken that the actual physical scarring that provided a form of medical corroboration of her account was located. Now that's an example of piecemeal disclosure. A fact came out which was very helpful to her case that she hadn't disclosed previously.
I thought she had disclosed that. It's just there hadn't been any medical evidence about that. I'm really just coming back to the evidence about the difficulties in making disclosure. I'm looking at paragraph 30 of Cohen, is it?
Yeah.
Disclosing past experiences, and am I correct to contextualise that by thinking of women who have been in the system for quite some time who've not made disclosures?
Some are. I don't have statistical evidence any which way. There may be people who have just arrived, whose claims may have been certified, so that they've had no appeal, or under the various new procedures in the Nationality and Borders Act have been held not to have any right of appeal. So there are going to be people in a situation where there hasn't been any detailed consideration. For example, if they're considered to come from a country where there's no risk.
Mm-hmm.
But where a woman does have such a past set of experiences that are relevant to her detention and removal, they become acutely more relevant in the days leading up to a proposed removal or following a detention. My Lord, I can now turn to the question of disability evidence. This is much shorter. The appellant herself is partially deaf. We've seen Lily Parrott's witness statement already, so just for the reference, SB 207 at paragraphs 44 to 45. And then Dr. Cohen's evidence again, SB 276, paragraph 11.
SB
276.
Thanks so much.
Paragraph 11.
Thank you.
And then the sixth reason, assessing how a client may appear as a witness. And here Ms. Patel refers to that at paragraph 22, SB 219. paragraph 22. In the event an individual who's been signed up to an IRC surgery is provided with legal representation by the firm may carry out further in-person appointments with the individual at the IRC. There's no limit on the number of in-person appointments the firm may provide to a detained client. The only limit is that the appointments are deemed necessary, but there's no question that the LAA recognises that in-person visits may be necessary. The cost assessment guidance for use with the 2018 civil contract states that it's clearly reasonable to interview a witness once. The fee owner will usually wish to probe the information given and to get some view of the likely impression that witness might make on the court. Sometimes it may be reasonable to see a witness a second time and go through the statement prepared and get it signed, though this should be less common. Further attendances to ask additional questions should only be allowed if there's good reason. Paragraph 2.43, the advice recognises travel to the client may be reasonable or justified instead of remote communication.
Just give me the context. I mean, I'm not sure which court. I mean, this is somebody who is facing removal.
Yes.
What? How does that apply? I understand. You know about. Yeah, I'm struggling with at the moment with the context.
So this is following the surgery, or as it may be some other mechanism by which the client is identified, the client can then either be granted legal help, which is a limited legal aid provision, or then what Ms. Patel's there called legal representation, which is up to quite a high limit of cost and a more open-ended form of legal aid.
Yes.
And recovering that legal aid from the LAA in accordance with the guidance.
Yeah. But sorry, the critical characteristic of the cohort we're talking about is the particular vulnerabilities we've been looking at.
Yeah.
From past experience and the like. If that person is identified as belonging to the cohort, what happens to them? I thought that they are then identified and will be released from detention, no?
Well, then the solicitor will have to fight for that person to be released. They'll have to persuade the Secretary of State that, contrary to what the Secretary of State thought 2 weeks before, this is not somebody who can be lawfully removed back to the country of origin. And so evidence will need to be prepared and submissions made as to why there is a fresh issue that hasn't already been dealt with if there's been a previous appeal, etc. Bail applications made, judicial review applications made, and so on. So that's the situation that someone in detention will find themselves.
But I thought, maybe I've misunderstood. Once it was identified that there's a reasonable argument to that effect, that this is
victim of trafficking, for example.
Then are you saying that there's then a court hearing to decide whether they should be removed? I mean, what?
So
I'm struggling with the court, the reference, the impression they're going to make on a court.
Take SPM, identified 16th of February, reasonable grounds, accepted by the Secretary of State. Solicitor writes to defendant saying, now release her. Defendant doesn't release her. We issue this very claim in order to get her released from detention because...
Sure, but where does an appearance of the person before a court come into that process?
So if she is accepted as having a fresh claim, then the Secretary of State considers it again on the basis of whatever evidence is presented as part of the fresh claim, and the acceptance of a fresh claim means that you get back into the appellate system, so you're given a further right of appeal, even if you've already had
and the person is then released.
Well,
if successful.
Pending the determination.
They may say, I'm going to detain you because I think you're a real risk of absconding, etc. Pending your appeal, there's no automatic release.
Where does the impression that the person witness might make on the court come into that any part of that process?
Because what you have to assess in deciding whether you think your client has a fresh claim is whether they could win on an appeal. So that's the test. Is there a realistic prospect that this person will win on appeal, bearing in mind this new evidence that they were trafficked, which wasn't there before? Well, if that person has a long history of being found not to be credible, and then also comes across in interview as not credible, that's relevant to factor in. Whereas if it seems that the previous finding, as in this case, was not credible, was premised in part because there was no other corroborative evidence, then a different view can be taken. But the way in which the witness appears is adverted to in the guidance as a factor of relevance to assessing whether to pursue that case for the person.
Okay.
And while we're here, my lord, this is the part of the statement which, at paragraph 24, deals with the...
But is this not... Sorry, I'm sorry. This is to do with civil legal aid for a court case, isn't it?
No, it starts at 21 with the advice surgeries. And then what it's then going on to deal with is legal representation, which would ordinarily, as in SPM's case, involve further representations as the first step, because you've got to get back into the 353 fresh claims system. So you don't go straight to a court case, but it could be, because here there's a judicial review. So
yes, this guidance, though, you've referred that this is talking about the cost assessment guidance for the 2018 standard civil contracts.
yes,
Seems to be talking about a solicitor on legal aid interviewing a witness with a view to give or to form a view as the impression the witness might make on the court.
yes.
And sorry, my question was that this seemed to be directed at a different type of process than
I'll check that. It may be that
we're dealing with here.
Well, it may be that specifically it's considering the appellate stage, but what Ms. Patel is trying to articulate here is that even at an earlier stage, in our client's case, there's no point in initiating a fresh claim if you can well foresee the Secretary of State isn't going to accept there's a fresh claim, and you can well foresee that if you try and appeal, that witness is going to be hopeless on appeal, so that there's no chance of winning, then you've got to apply the merits criteria to it. So what she's saying is that a component of that exercise of assessing the merits is seeing the witness person to person, and therefore a component of being able to give advice to the client and say, you're going to make a really good witness, you should definitely try and go for another appeal, or
I think I don't think the court's going to believe you.
Yeah,
so
you've got this history of lying in the past. You don't come across as credible. You're not giving a consistent account, etc. You're never going to be able to get back from the position of not having been believed in the past. And she's saying to make that assessment, an in-person attendance can form part of the matrix of things that are considered.
Okay.
And then at 24, this picks up the point about funding trips. But I also took the court earlier to the second witness statement, which clarifies that on the surgeries that travel is not paid for.
Mm-hmm.
So that's my run through of the evidence and the six points as to the need for face-to-face legal advice completed, and I turn then to how the judge dealt with that. That's at 42 to 50 of her judgment, which is at Core Bundle 103 to 105. And in essence, we see that she acknowledges and summarises those statements at 46 to 49 that I've referred to. Then her conclusion proceeds from that.
So which paragraphs were you on just now? I
Sorry, I just wanted to acknowledge the way in which the judge had adverted to the evidence, which is at 42 to 50 in her judgment.
Do you say the judge got her summary wrong in any way?
No. And then at 103 there's a heading, interim contingency arrangements from January to June, on page 121. And then at 106 begins, in my judgment. That's the key passage really. And at 108 she concludes therefore not unlawful, and at 110 acknowledges the role of the Lord Chancellor.
Is this right? You say, and maybe it'll be preempting what you're going to say, you're saying that section 27.2, as applied to the Lord Chancellor and the provision of legal aid, doesn't matter because it's all to do with the question of whether there's sufficient access to justice when the Home Secretary decides to move people to or locate people at Derwentsside.
Yes.
On the particular facts then being present there. And it's,
yes.
Which is why you say it doesn't actually matter what the Lord Chancellor does about the provision of legal aid by various means. It's not addressing the point.
Correct. So my client's claim was a claim to get to be released from detention, now a claim for damages for false imprisonment. Bringing a claim against the Lord Chancellor wouldn't achieve either of those objectives.
Putting it a different way, if the Lord Chancellor says, well, I'm entitled to provide legal aid by any means I want to, I paraphrase section 27.2, that I think appropriate, this is what I'm prepared to do through the agency. That doesn't answer the question about whether what's available at Derwentsside denies access to justice, which is a question for the Home Secretary before she moves people there.
Yes.
And if the legal aid isn't sufficient, some other means would have to be found, you say, to plug the gap.
Yes, or not detain.
Well, or not detained there, anyway.
Not detain there, yeah.
Yeah, which is why you say section 27.2 isn't just a slam dunk answer.
No, I mean,
okay.
So exactly, my Lord has summarised stuff. What I was anticipating saying on that. Just to come back to 106, the point we make in our skeleton argument then is on the anxious scrutiny point, as it were, because clearly I have to both make my case de novo before this court, but also in relation to the ground of anxious scrutiny on which the appeal is premised. We submit at paragraph 38, the analysis doesn't engage with the heart of the appellant's case, namely that vulnerable detainees using only remote means of communication would not be able to make timely disclosure, engage adequately with the representatives to ensure their case could be properly prepared. And the evidence before the court showed that remote-only legal advice posed a real risk of being ineffective. The judge rejected that argument without engaging with the detailed evidence to the contrary before her.
You don't challenge her. She got the legal test right, didn't she, in the first 3 lines? So it's not that, it's a lack of engagement with the evidence, you say.
The denial of effective access to justice in
that's the
real
right
world
test,
conditions is a fair summary
That's
of
fair.
the legal test, yes.
So it's the next sentence, really, isn't it?
Well,
Where
one
she-
component of that first sentence which I picked up earlier is the for a limited 6-month period problem with the way she articulates the test,
Yes.
because that is a flaw. My lady's nodding. I don't need to repeat that submission.
Well,
but,
I'm nodding in because I remember the submission.
Yeah.
I
I
won't
don't
go
need
further at
to
this
go over
stage.
that again, but I picked up where it was made clear that this isn't where there is a breach of access, of effective access to justice. One can't weigh that against, oh well, it was only for 6 months. And we also object to the framing of the question as one of preference, as the judge suggested, because that's not a way in which the case was put, and in my submission is not the way in which the evidence leads. It's not a question of whether detainees prefer one form of communication,
Well, it's
one
not
form of
irrelevant.
communication to
Surely it's
another.
not irrelevant. Assume that all 3 forms of attendance were possible. Telephone, video and in person. The fact that the solicitors and the clients preferred to use the telephone, if that was right, would be relevant, wouldn't it?
Yes, if indeed that was the
And
the evidence.
it must still have some relevance when it's limited to telephone or video, that clients prefer telephone, if that is accepted. Because they're stepping away from what you say is absolutely essential for the proper presentation of their case.
Yes, and I mean the only real evidence we have on the question of preference, apart from that, well, someone unnamed from Mighty says they think this is the preference. That's the defendant's only point in it. But the only real evidence we've got actually is in what's happened subsequently in that
Well, we've
freedom of
got
information
we've got that.
report. Yeah.
We've got
So, insofar as we can attempt to bring preference in, I'd say that's the only evidence on which the judge could draw a conclusion.
I mean, it's quite the subsequent evidence is quite dangerous to sort of read too much into, because
It is.
you don't know what proportion of the people have been actually identified as vulnerable or non-vulnerable or
I agree.
suitable to be
I accept that.
contacted by telephone or not.
Yeah, no,
I just don't know.
I accept that, but and that really goes to my point that there isn't evidence about preference before the court, and the judge's adversion to preference misses the legal test that was being put to her as to compromising effective access to a lawyer and to justice.
Is the focus of your argument really on the words comparable to an in-person meeting? Because I think, as you've addressed us this afternoon, your central point is that it's not in-person is not comparable to video conferencing.
Yes.
And so that's really the nugget, isn't it? I think that is the
That is
real
that is
cause
certainly
of what you challenge.
yes. Yeah, that's an important nugget because in terms of the access scrutiny appeal point, what she does in saying video conference facilities with high-speed Wi-Fi were newly enforced and are comparable is essentially, from her own experience, take a view on that, but she doesn't engage with all the evidence. So, as far as us,
I mean, that's one that I wanted to go on and ask you. Was that a finding that was open to her, even open to her on the evidence, or do you say that this is an impermissible finding because it wasn't even open to her to reach that conclusion?
If I need to, I do say that, but my primary submission is that it doesn't engage with the evidence that was before her. Certainly, none of the evidence or no reasonable assessment of the evidence that was before her could lead to that conclusion. And one has to recall that that's because all the evidence is from the appellant's side, from experts, from solicitors dealing with these clients and making clear the shortcomings. That's what the evidence is about. And it wasn't as though there was a viable alternative statement from some expert who's researched it and presented that, a basis for that assessment. It's difficult to know where it does come from. Clearly for those court users who have used remote facilities in the past few years, in some circumstances, we may feel that that's correct, but that's not what was on offer in terms of the evidence to the judge. So we say that doesn't properly engage with the evidence.
Well, I mean, I think it's this right. You say it doesn't engage because what might be comparable for other people, the evidence suggests it's not comparable for the type of people who may have been present at the detention facility.
I do, yes.
And that risk, I think, is what you say is what triggers the potential illegality.
Yes.
Can I just check? In your skeleton, where do you provide a basis for your use of the terms anxious scrutiny and obligation to engage?
Yes,
I thought
we
you
do.
did, but I can't see it just at the moment.
Yes, we do. It's in the grounds of appeal.
And I know you put it in
And
your grounds of
skeleton
appeal.
28.
Sorry, what?
Skeleton paragraph 28.
Thanks so much. Right, so it's dependent upon acceptance that we're dealing with a fundamental right. And then if you get past that, then it's MN.
Yes.
Okay, thank you. Where do you want to go now?
So I'll take my lords and my lady back to the skeleton. 29 to 31 is then how we set out the ground of appeal.
And you've covered most of that, haven't you?
And I've covered that, so I won't read it out. And we say that SPM herself was falsely imprisoned for those reasons at 29 to 31, in kind with the other women at Derwent's side. I've handed up this morning lumber that explains two ingredients: detention and absence of lawful authority. Detention's not an issue. Authority must be pursuant to a statutory power. I've taken the court to the statutory powers, paragraph 16 and 18 to Schedule 2 of the Immigration Act 1971. We submit the defendant's not authorised to detain women in a place that compromises the effective right of access to justice. That is ultra vires. Indeed, it's common ground the executive is not authorised to exercise powers to detain in a manner that creates a real risk of impeding or hindering a right regarded by the common law as fundamental. See the detailed grounds of defence paragraphs 27 to 28 on CB 206.
Yep.
I've taken the court to all the authorities on general powers, and I submit statutory powers in general terms do not either directly or indirectly, do not authorise the executive directly or indirectly to hinder consultation with lawyers. And again, see the detailed grounds of defence, paragraph 28 and 31, some common ground on that.
28 and 31.
Of the detailed grounds of defence, which says the ability to communicate with one's lawyer is a civil liberty that Parliament cannot have intended to take away from persons detained under immigration powers, otherwise it would have said so explicitly. And that's a point indeed reflected in the judgment at paragraphs 79 and 80. In my submission, there is no express statutory authorisation within paragraph 18 to impede or hinder a woman's right to effective legal advice and representation when detaining her. And again, paragraph 31 of the detailed grounds of defence, CB 208, seems to concur on that premise. The right to access to a lawyer encompasses in some, though not all circumstances, a right to in-person attendance. And the detailed grounds of defence, again at paragraph 36, bring us to some common ground of it on that, in saying that claimants do not assert a fundamental right of face-to-face access to a lawyer in all circumstances. There are cases that women at Derwent's have such a right by virtue of a real risk, they say, remote means of communication may lead to an injustice. In 3 types of cases where vulnerable women do not reveal information remotely that they would reveal to an advisor had they spent time in person, where women are suffering from the results of trauma and mental illness.
Forgive me, Mr. Goodman, what are you reading from?
Sorry, there's detailed grounds of defence.
Thank you. Paragraphs?
Page
36 was...
Thank you.
And 37, Secretary of State in the detailed grounds of defence does not accept that face-to-face contact with a lawyer is invariably necessary in all such cases. It's a question of fact. And at 38, the Secretary of State does accept, however, that there may be cases in which a solicitor's professional judgment is that face-to-face contact is more appropriate than a telephone call or video conference. I accept that there is no rule prohibiting face-to-face contact, and that's detailed grounds of defence 28, but a practice overall which creates a real risk individuals be prevented from having effective access to a lawyer. So there's some measure of common ground in terms of the legal principles, and the battleground is whether detaining women at Derwent's involves a real risk of breaching the fundamental rights of detainees to effective access to legal advice and representation, by reason, I submit, of the practical real-world impediments and hindrances to accessing face-to-face attendance and advice by a lawyer. And the context for this, is the point I wish to emphasise, is the fundamental rights in question. So people facing removal, facing Article 2, 3, 4 right breaches on removal, and people whose liberty is being deprived. And one of the features of the system of administrative detention, so it's detention by the executive, is that the guarantee of its lawfulness is the right of access to the courts. That's the common law position, and that's reflected in Article 5.4 of the Convention as well. So we have an exception to the usual rule about deprivation of liberty is these exceptional powers of executive detention, either in the mental health context and in the immigration context. The guarantee that, unlike a judicially authorised detention, that precious right to liberty will be safeguarded is the right at least to a retrospective analysis of that through habeas corpus proceedings, for habeas corpus traditionally, or judicial review. So access to the court in questions of liberty is integral to the power to detain people in the first instance. And so that connects to what Lord Reid says about access to justice being a component of the rule of law itself. It's inherent in the system of executive detention that there must be a system of accessing the courts in order to challenge that. And that is intrinsic to the proper exercise of the rule of law, of a system of the rule of law. And so it's therefore of the power to detain that Parliament anticipates and expects that a person may bring proceedings to challenge and will be in a position to challenge that detention. And see also Articles 5.4 and 5.5 of the European Convention on Human Rights. And so that establishes the fundamental rights context akin to Unison and the other authorities we've looked at, within which this right of access to justice is to be set. And of course it is one of fundamental rights. So, in my submission, there was a breach of the right of effective access to justice. Now, the final matter on which I had some submissions prepared is to address the respondent's case. What I could do, given the time, is either spend 10 minutes on that now or hold over till tomorrow.
Well, let's just see how we're doing. We're listed for 2 days.
Yes.
Is that in any danger?
My lord, I don't think it is. No.
Right. So would you be content to do your response to what you've heard, deal with the respondent's notice, and then for Mr. Goodman to reply?
Yes. And I was going to propose, given the time, I have my friend's submissions have something of a sense of an ending about them, as he's speaking now. I was going to propose that if he's drawing to a conclusion now or shortly, I ought to start mine afresh in the morning.
Yep.
Rather than giving you 5 minutes now.
Yep. Subject to responding to the respondent's notice. Have you finished?
Yes, ma'am.
Well, you've taken what I can politely call quite a battering during the course of the day, and you've stuck to it manfully. And I'm sorry if we've blown you off task from time to time, but I think we understand the submissions you're making.
Can I just ask one question, I do have one final question. Do you mind?
You don't get away that easily.
I'm only here to help.
I just wanted actually to circle back
Yes.
to the relief that you...
To the relief, yes.
which you can pick up at
point to circle back to. Yeah.
301 of the call, I think. Sorry,
Yes.
301 of the call, which I think
Yes.
you said this morning. So I just want to sort of just check I've understood what you say we should be doing if we're with you.
Yes.
And as I understand it, you say, A, a declaration should be made that detaining women at Derwentsside Immigration Removal Centre under the circumstances pertaining, now it would be between the 28th of December 2021 and the 1st of July 2022, I think.
Or the date of the hearing before the judge, because that actually coincided with, I believe, the award of the new contracts, but around then.
Okay. And it's involved, therefore past tense, a real risk that the persons so detained were, or so would be prevented from having access to justice. So it's the real risk that the persons so detained would be effectively prevented from having access to justice. Is that
Yes.
right? Or some such wording. And then
Yes.
a declaration that the detention at Derwentsside, of women at Derwentsside, for that period in those circumstances was ultra vires.
Yes.
And then I think you said E, which was
The claimant's
your
specific.
client specific, i.e. she was, this picks up a point my lord made to you, your first two are entirely structural. They're not, in other words, your client was within the group of people under A and B, but you want it specifically spelt out for her.
Yes.
Yes.
Yes. Although it does follow on the way in which the arguments.
Yeah, I
But-
think there's something slightly wrong with E. It talks about access to effective access to justice, but I think subject to you tweaking the wording. And then F is really, again, the mirror of B, but specifically by reference to your client, is it?
Yes.
So F just,
Yes, I
F,
mean,
just,
so-
F just mirrors B.
Yes. I mean, the way the claim was originally put, obviously there were other grounds. So E and F so F would have related both to this point and to the other grounds. But if I
I mean,
obtain that declaration from my client on F,
well,
for this ground,
yeah,
that
I
would
mean,
probably dispose of the remaining grounds.
I think I get it, but speaking for myself, it would be quite nice to at least see the updated wording.
With the past tense in it and so on.
Well, and you know, with other infelicities of wording eliminated, so that we know what it is you want.
Yes.
And then that also gives a target for Mr. Rowe to aim at. I mean, he's probably pretty clear where his target is, but that would make it explicit, I think. Certainly for me as well, anyway.
Yes.
Yeah. And then J and M were the other two, but you're suggesting that if we were to make the other orders, that those would be remitted elsewhere.
Well, costs on the appeal, obviously.
Well, yes.
Yes, but on the yes, the damages would be remitted to probably to the King's Bench Division of the High Court or the County Court.
Okay. Right, thank you. That was all. It was fairly easy.
By today's standards.
Well, I'm very grateful.
Thank you very much indeed, Mr. Goodman. 10:30 tomorrow.